Honor, part of it. I don't think they've met their burden. Um, they certainly have put on evidence that the weapon was stolen, but we don't know when that weapon was stolen. We don't know the circumstances. And you're wondering why that's important, why that matters.
Well, I'm wondering why you're saying that to me. I mean, if it were stolen 10 years ago as opposed to the day before, will it matter for me?
It would, because the prosecution would certainly jump up and argue that if it were just recently stolen, that he would obviously have some sort of not that would obviously mean he had some knowledge it was stolen, because recent possession would sort of point to that.
Oh, I
so I'm taking that argument out of their mouths. They have to be able to show that he had some knowledge that the weapon was stolen. So what do they have? He paid a lot for it. That means he knew it was stolen. I think even at a probable cause level, that's a stretch. Because basically, I can tell you this, I'm not a weapons guy. I don't know what one pays for weapons. If someone wanted to sell me a weapon and said it's 150.
Well, I am, and I think probably 50 was too high. But
all right, you are. But we don't have any evidence that he is. There's no evidence here that he would know that. And so if you're going to try to argue, oh, well, he paid too much, that means he knows it was stolen. Well, you have to show that he would have known that. You have to show that he would have had that knowledge. If that's going to be your argument for knowledge that he knew the weapon was stolen, they have to put on something that tells you that he knew the weapon was stolen. So what I'm doing here is I'm trying to take those arguments out of their mouths. That's exactly what I'm doing here. The argument that recent possession of something that was recently stolen might lead to an inference that he knew it was stolen. The idea that because he paid so much or a particular price for a weapon, that he must have known it was stolen, without showing that he's the knowledgeable person about what weapons would cost. And you have to set aside your knowledge on it. You have to do that.
Well, I certainly can set aside my knowledge, but I'm just saying, I mean, there's other indicia. The fact it wasn't registered. I mean,
okay.
Because it wouldn't have come back stolen if it had been. That's the reason I can say.
Well, yeah, okay. Well, I'm not arguing that the weapon wasn't stolen, but I'm arguing that they haven't shown that he knew it was stolen. I'm arguing that they haven't shown anything that says he had the knowledge that this is a stolen weapon. Okay, so it wasn't registered. All right. So how long had he had the weapon? We don't know that. There's no evidence to say how long he had it. There's no evidence to say that he didn't just pick up that weapon the day before and maybe he was going to register if he thought he could. None of that's there. Buying a weapon doesn't, even if you buy it under illicit means, doesn't mean that you know it's stolen. It just means you bought it illicitly. It means you bought something you shouldn't have bought. That doesn't mean that it's stolen.
Okay.
So the bottom line is, Your Honor, they do have to put on some evidence or some evidence from which it could be reasonably and logically inferred of his knowledge of the nature of this weapon, that it was in fact a stolen weapon. None of that is here. You can talk about all you want. Well, he shouldn't have paid as much as it. It was such an ugly weapon. Why would he pay that much? Or it wasn't registered. Those things don't matter if they don't show that this person, this individual, had knowledge that this was a stolen weapon. Could have been something somebody found, somebody tossed away. Could have been.
But it's knowledge or reason to know.
All right. Well,
right. And
so, all right. I love that.
Wouldn't that really be an issue of fact?
No.
Given all the circumstances?
No, because they have to put on some evidence from which you can infer that element. They have to put on evidence of all the elements. And the necessary element here is that he should have known or had a reason to know it was stolen. None of the things that they talk about will lead to that conclusion. None of the evidence they put on will lead to the conclusion that this individual, knew or should have known this was a stolen weapon. He might have known that he bought it illicitly. He might have known that he shouldn't have a weapon. But none of that says that he knew that this particular weapon was a stolen weapon. And that's what they have to show. If they're going to say that he should be bound over on receiving and concealing a stolen weapon, that particular knowledge. And it's just not there.
Right.
So as to the others, the carrying and concealed weapon, possession by a felon, I think those are actually issues for the trial. But the one it's not an issue because they haven't made an issue because they have not put in sufficient evidence for you to logically infer that he had knowledge that this was a stolen weapon.
Thank you. When we were here on April 2nd, 2024, Trooper Chowdhury testified. During his testimony, I admitted the defendant's admissions to Trooper Chowdhury. Trooper Chowdhury testified that the defendant told him that he had purchased the firearm 2 days prior and that he had purchased the firearm from somebody by the name of Jay, that he wouldn't provide any further details about who Jay was or the information about the sale. So when I layered that prior testimony on top of today's testimony, the defendant paid too much, $125 for a high point, and that the high point was in poor condition, in this painted condition, and that it's returned stolen, I do certainly have at least a probable cause and a question for the jury as to whether or not this defendant knew or had reason to know that this firearm was stolen.
Kind of not wanting to get Jay in trouble with illicit weapons. It's not knowledge that it was stolen. That's a leap. It's a huge leap.
What's a huge leap? That some guy named Jay sold an overpriced weapon to somebody, that's a huge leap as to whether or not I know it's stolen.
Exactly right. It's illicit sales. Maybe he knows he's not supposed to have a weapon. Doesn't mean he knows it's stolen. Again, he's not trying to bring everybody else down with him. He'll end up in the kitchen.
Thank you, Mr. Brown. Having heard all the testimony, and as to count one, certainly the people who have sustained their burden and the court would find the defendant overstand charge trial on count one. As to count two, there's been much talk about the receiving and concealing and the defendant's knowledge of that. There is certainly, people haven't shown his direct knowledge necessarily. There is certainly evidence by which a fact finder could infer that the defendant had knowledge. One, the purchase of a firearm at an amount, by the testimony of Mr. Spencer, at an amount more than really twice what he paid, what he would have paid for that same weapon, having knowledge of that weapon. The fact that there's an admission that he purchased it from some guy named Jay 2 days prior. The weapon is not registered, so it comes back stolen. All of those things, I think, can be used to, at least by a fact finder, to infer that the defendant had some knowledge that this was indeed a stolen weapon. So for those reasons, the court would find that the people have indeed sustained their burden as to count two and would bind the defendant over on that charge also.
Yeah.
Mr. Brown, with the addition of the April 22nd to 23rd day,
There will waive the presentation information. My client will still enter.
defendant having waived reading and presentation, court will enter as not guilty plea as to both counts. Pre-trial in this matter will be set for
June 4th at 1:30 before Judge Conkey.
June 4th, 2024, 1:30.
A tense legal debate unfolds in court as attorneys argue over a critical question that could determine whether a serious criminal charge moves forward to trial. At the center of the dispute is a firearm that police confirmed had been reported stolen. Prosecutors believe the defendant knowingly possessed the stolen weapon, but the defense strongly challenges that claim, arguing that the prosecution has failed to prove one crucial element of the crime, knowledge, according to the defense attorney. Simply proving that a weapon was stolen is not enough to justify the charge of receiving or concealing a stolen firearm. The law requires something more. The prosecution must also show that the defendant actually knew the weapon was stolen, or at least had reason to believe it was stolen, and that, the defense argues, is where the case begins to fall apart. The attorney carefully explains that the prosecution never established when the weapon was stolen or under what circumstances it disappeared. Without that information, it becomes difficult to draw conclusions about whether the defendant should have suspected anything was wrong. For example, if the weapon had been stolen years ago, the situation would look very different than if it had been stolen just days before it was discovered in the defendant's possession. The timeline matters because recent possession of stolen property can sometimes create a legal inference that the person knew it was stolen, but in this case, the defense points out the prosecution never presented evidence showing when the theft actually occurred. The attorney then addresses another argument that prosecutors might rely on the price the defendant paid for the firearm. During testimony, it was suggested that the defendant paid significantly more for the weapon than what it would normally be worth. The prosecution believes that paying an unusually high price for a damaged firearm could indicate that the buyer knew something suspicious was going on. However, the defense dismisses this argument as speculation. The attorney argues that unless the prosecution proves the defendant was knowledgeable about firearm values, the price alone means nothing. Someone unfamiliar with weapons might have no idea what a fair price should be, simply paying too much for an item does not prove that someone knew the item was stolen. The defense also addresses the fact that the weapon was not registered. But again, the attorney explains that even if the purchase was technically illegal or informal, that does not automatically mean the buyer knew the weapon had been stolen from someone else. In other words, buying a weapon through unofficial channels might show poor judgment, but it does not prove knowledge of theft. The defense concludes by emphasizing a key legal principle: every element of the charge must be supported by evidence. Without proof that the defendant knew or should have known the firearm was stolen, the receiving and concealing charge should not proceed, but prosecutors quickly push back. They remind the court of testimony given earlier by a state trooper who interviewed the defendant during the investigation. According to that testimony, the defendant admitted that he had purchased the firearm just 2 days earlier from someone he identified only as J. The defendant was unable or unwilling to provide any additional information about the seller. For prosecutors, this detail changes the picture entirely. They argue that purchasing a firearm from an unknown individual shortly before being stopped by police, combined with the fact that the weapon was confirmed stolen, creates enough suspicion to justify letting a jury evaluate the case. They also point to the poor condition of the firearm and the unusual price the defendant paid as additional factors that could suggest the defendant should have realized something was wrong. In the prosecution's view, these circumstances together create a reasonable inference that the defendant knew, or at least had reason to suspect, that the weapon was stolen. The debate ultimately shifts to the judge, who must decide whether the evidence meets the legal threshold required to send the charges to trial. After reviewing the arguments, the judge begins delivering the ruling. First, the court determines that the prosecution has clearly met its burden for the primary firearm charge. That count will move forward. Then, the judge addresses the more disputed allegation receiving and concealing a stolen weapon. The court acknowledges that there is no direct evidence proving the defendant knew the firearm was stolen. However, the law does not always require direct proof. Instead, the judge explains that a fact finder, such as a jury, is allowed to draw reasonable conclusions from the surrounding circumstances. And in this case, several factors stand out. The defendant admitted buying the firearm just 2 days before police recovered it. He purchased it from an unidentified individual known only as J. The weapon had been reported stolen, was not registered, and testimony suggested that the price paid for it was far above its normal value. Taken together, the judge concludes that these circumstances create enough evidence for a jury to reasonably consider whether the defendant knew the firearm was stolen. Because of that, the court rules that the prosecution has met the minimum legal standard required at this stage of the case. Both charges will therefore proceed to trial. With that decision, the judge formally binds the case over for further proceedings and schedules the next hearing. As the courtroom session comes to a close, The ruling highlights an important aspect of criminal law. At this stage of the process, the court is not deciding guilt or innocence. Instead, the judge's role is simply to determine whether enough evidence exists for a jury to hear the case, and in this situation, the court has decided that the question of what the defendant truly knew about the firearm will ultimately be left for a jury to decide.